Contracts are all about creating rights and duties between parties, but what happens when those rights or duties need to change or end? In the legal world, a right is a privilege protected by law, giving one person a claim against another. This claim could be for money, goods, services, or even to prevent someone from doing something. Sometimes more than two people are involved in a contract, leading to co-debtors or co-creditors. For example, two people might buy a car together, or one person might owe money to several creditors. The way these rights and duties are divided depends on the intentions of the parties and the nature of the contract. Throughout this video, we'll explore how these rights can be transferred, varied, or terminated by agreement, and what legal principles guide these changes. One of the key ways rights change hands is through cession. Cession is the legal process where a creditor transfers their personal right to another party, known as the cessionary. For example, if Bengani is owed money by Naledi but owes the same amount to Simfu, Bengani can arrange for Naledi to pay Simfu directly. This is done through a cession agreement where Bengani, the cedent, gives up their right to receive payment from Naledi, passing it to Simfu. Cession doesn't usually require any formalities or even the debtor's consent, and it can apply to both existing and future rights. However, some rights can't be ceded, such as pensions or rights that are too personal. The law also protects the debtor from being put in a worse position because of a cession. Understanding cession is crucial for anyone dealing with contracts, as it allows flexibility in managing obligations and claim. There are two main types of cession: complete cession and cession as security. In a complete cession, the right is fully transferred to the cessionary, who then becomes the only person entitled to enforce that right. For example, if Danny cedes the proceeds of a savings policy to Tandeka in exchange for a loan, Tandeka will receive the payout directly when the policy matures. Cession as security: the right is transferred to secure a debt, but it can be returned to the original creditor once the debt is paid. For instance, if Sibusizo cedes a life insurance policy to a bank as security for a loan, the right returns to Sibusizo after repayment. The main difference is that complete cession is permanent, while cession as security is temporary and tied to the repayment of a debt. Both types ensure that parties can manage risks and obligations effectively. Contracts aren't set in stone. Parties can agree to vary or end their rights and duties in several ways. Variation means changing the terms of the contract, such as adjusting the amount owed or the services provided. Release occurs when a creditor agrees to relieve a debtor from their obligation, effectively canceling the debt. Delegation allows a debtor to transfer their duty to someone else with the creditor's consent. Assignment involves substituting a third party for one of the original parties, transferring both rights and duties. Novation replaces an old duty with a new one, while compromise settles disputes by agreeing on new terms. For example, if two tenants agree with their landlord to change the rent amount, that's variation. If one tenant's mother takes over the rent payments, that's delegation. These mechanisms provide flexibility, allowing contracts to adapt to changing circumstances and helping parties resolve disputes without going to court. Summary: the passing, varying, and ending of rights and duties by agreement are essential tools in contract law. Whether through cession, variation, delegation, assignment, novation, or compromise, these mechanisms allow parties to adapt their agreements to new situations, manage risks, and resolve disputes. Understanding these concepts helps ensure that contractual relationships remain fair, flexible, and legally sound. By knowing how and when rights and duties can be transferred or changed, individuals and businesses can better protect their interests and maintain healthy, cooperative relationships. Always consider the legal requirements and implications before making changes to any contract, and seek advice if you're unsure about the best approach for your situation.